Your company has suffered a data breach. Credit card numbers and other personal information for thousands of your customers have been compromised. What do? Do you have to notify your customers about the breach? And if so, what do you tell them? How quickly, how soon do you need to notify them? Answering these and other questions involve a tangled web of overlapping and sometimes conflicting state laws. Since 2002, when California enacted the first data breach notification law, 46 states have all enacted separate laws that require you to notify consumers, and in some cases, state authorities in the event of a data breach. So which state laws apply to you? Well, if you do business in or maintain personal information for residents in more than one state, you'll need to look at multiple state laws in deciding how to respond to a breach. It's possible that you may be able to draft a single notice that complies with multiple state laws, but some of those notices may still need to be tailored to specific states or circumstances. You'll need legal guidance to get all of this right. Here are some other issues you'll want to consider. First, what personal information is protected? Many states protect Social Security numbers, driver's license numbers, credit card numbers, information that can be used to access a person's financial resources. But some states go much further. They protect digital signatures, biometric data, fingerprints, medical information. Second, when is notice triggered? Many states require notification when there's unauthorized access and unauthorized acquisition of personal information. In other words, the thieves actually have to have hacked into and taken your data. But in a handful of states, unauthorized access alone is enough to trigger the necessity to give notification to consumers. And as a practical matter, news travels fast. So if you have to provide notice of a breach in one state, it's generally a good idea to provide notice to affected customers in other states as well, even if you're not sure of your obligation to do so. So you know who you're going to give notice to, you know when you're going to give notice. What do you have to say? Well, include a short, concise description of the incident. Don't mislead. Don't withhold key details. The notice should be concise and direct about the incident itself. Depending on state law, you might need to include the number of state residents affected or describe steps the company has taken to correct the problem. The notice might also require that you provide advice to consumers about how they can fix the breach or at least protect themselves from any harmful effects that might result from the breach. What's the time frame for this notice? Well, today is always better than tomorrow, and yes, a swift response is essential. And speed is important because it's mandated by state law. Some state laws require notification immediately, but some say within 45 days. Others say without unreasonable delay. Keep in mind, quick does not mean sloppy. Notice that's too fast or unmeasured may include incorrect information. It may invite unnecessary panic. It could further damage your company's response to fixing and correcting this problem as accurately and legally as possible. Finally, should you notify both state or federal authorities? Some states explicitly require notice to the Attorney General, but even if not required by statute, you may want to bring in law enforcement authorities to investigate the circumstances of the breach. In other instances, you may want to go to the federal law enforcement authorities and get their involvement if it's a matter, in fact, for the Secret Service or the FBI. At this time, there's no nationwide breach notification law. In other words, no single statute or body of law that governs when you give notice. But keep in mind that the Federal Trade Commission, the FTC, has taken an increased interest in data privacy and may launch an investigation of its own, depending on the circumstances. The consequences of failing to get the notice right, of failing to comply with any applicable state law, could be substantial. Not only could it potentially harm your reputation and brand, but some state laws give consumers a private right of action to sue for failure to comply with notice requirements. An Attorney General could also bring an action. The attorneys at Womble Carlyle, we have the resources, we have the judgment to help you respond effectively. I'm Jay Silver. Thanks for watching Womble Carlyle Tech Briefs.